All right, hello everybody. We're gonna wait a minute or two until we start so people can arrive. All right, well, the last few people are coming in. I guess we can get this going. Hello everybody, welcome to part 2 of our legal workshop webinar series. And yes, well, let's get things going right now. Before we start, for real, I have some housekeeping rules that I wanted to discuss with you for those who weren't here last week. Everybody is muted during the webinar, but you're still welcome to ask questions. Please use the little chat box on the site. I will see to it that those questions get answered. I will interrupt our speakers if the question makes sense for that point in time. Otherwise, we'll have a Q&A session at the end. All right. And we have prepared some little surveys for you during which you will asked to please participate. All right. So the whole CSA summit this year is, you could say, under the motto of bridging the gap somehow between the digital world and the non-digital world, you could say, because now we've had to transfer all of this into the digital realm, which is fine. But this also goes for the legal workshop this year, because we want to bridge the gap that is left by, well, maybe just the missing knowledge with customers of ESPs or something like that. So this is why we deal with issues here that we determine during our complaints processes and during the certification process. So this is what we're going to focus on today again. I'm saying we, this is us. Today's speakers, I welcome Alexandra Koch-Skiba and Astrid Braken, who will be speaking. I am Sebastian, the third person you can see here. Alexandra, just for those who don't know us, Alexandra is an attorney and she's the head of the complaints office. She has basically the oversight about our report handling. She's in contact and with the certification committee, and she also reviews and updates CSA rules. Astrid is responsible at CSA for legal advice. She also does the legal checks during the certification process, and both of them are presenting here today. Last but not least, me, I am a consultant at the ECHO Complaints Office, so I handle reports and CSA complaints cases, and also today I am here as your moderator. All right, kicking it off from last week, we've seen this as basically the main breakdown of what we encountered being problems last year. The biggest chunk being insufficient permission data. So this is why last week we talked about documentation and why it's important and how to do it. The second biggest part was consent, everything that has to do with consent. And we've added this little other chunk right here, which includes all issues that we've encountered that have to do with customer relationships. So we're gonna kick it off with permission-based problems today. And for this, I hand over to Alexandra.
Thanks, Sebastian, for your introduction. Let's start with a short brush-up of basics concerning the permission. I guess you all heard often the sentence, when sending advertising emails, you should have a permission. So for me, 3 questions are coming up. What is permission? What is its legal basis? And what the hell is advertising? So we want to look at this first before we go into detail. In short, permission is having a consent of the recipient or fulfilling requirements of an exceptional case of sending emails without a consent. The legal framework for EU-related email marketing are 2 legal frameworks, to be concrete. It's the e-privacy directive and the GDPR. Both state that advertising emails are only allowed if you have a specific consent of the recipient, or if you don't have that consent, if a customer relationship exists, but then you have to fulfill additional requirements. So when you are sending advertising emails or newsletters, consent is required, or you must have additional requirements fulfilled to be allowed to send these kind of emails. That's the situation that applies for Europe, but even if you send emails outside Europe, it's good to comply with these requirements, with these guidance, because in many countries there's a very similar legal framework, and even if not, it's now common best practice to have a permission when you are sending advertising emails. So if you stick to what we are presenting to you afterwards, then you should be on the safe side. So let's come to the entrance questions, so to say. What is advertising? Because all of this applies only if you're sending advertising email. From a legal point of view, there is a very broad interpretation and definition. Advertising is any statement promoting the sale of a product or a service, directly or indirectly. So whenever things are communicated in order to sell a product at the first, second, third step, whatever, then we are talking about advertising, and you need to have a consent or specific requirements fulfilled for exceptional cases. So talking about a broad definition, I have to state that advertising is applying, so to say, or something qualifies as advertising if you're sending emails aiming for customer care, or even if you're sending satisfaction surveys. So always think about the broad definition. That's what we want to recommend to you here. I don't think we have to talk about the definition of transactional emails who are in distinction with the advertising emails. I guess you're more than very familiar with these kind of emails. But please keep in mind, even if transactional emails include some kind of advertising elements, then again, you have to have a the permission for sending this. There are also some borderline cases. I guess you all are thinking of some of them. I just want to focus on a case that came up very often in the last year or years. It's about sending emails that inform users about new functionalities of specific portals or service emails. So even in this situation, we consider these emails as advertising because the original aim of these emails is also to keep your customers. So it's about customer retention, and in the end, it's about the indirect promotion of the service or your product. That's why we think these kind of emails qualify as advertising here. I hope this introduction is a good brush up of the basics of the permission, and now I hand over to Astrid for more details, information about consent.
Okay, thank you very much, Alexandra, and warm hello from me for our information today. Well, what are the requirements of a consent? We have 4 main requirements, prerequisites. It has to be given in an active way. It has to be given separate, free, and the data subject has to be informed. So first of all, what means active? Well, if the consent is given in an electronic way, that means that clicking a checkbox is okay. What is not okay is if there is already a pre-selected click. What means separate? Separate means that there should not be a combination with the consent and other declarations, of course. What means that the consent has to be given in a free way? Well, this is if a person has a genuine or a free choice and is therefore able to refuse consent without suffering any disadvantages. Well, and the last and most important point is that the data subject has to be informed. And there are 2 important points, of course. The consent has to be precise and there has to be a notice on how to revoke consent. Now we turn over to the next slide, and here we talk about some examples and about some general definitions that the courts in Germany have given on this complex. Well, first of all, the Federal High Court in Germany and the Higher Regional Court have given the following general hints in this context, namely that the data subject must be given the opportunity to understand the consequences of the consent, and it must be clear to the consenting party which products or services of which companies the consent is specifically recorded. Well, let's now have a look at some examples on which the courts in Germany have ruled. Concerning the number of sponsors, there is now, in the last year, a legally binding ruling from the Higher Regional Court of Frankfurt, in which a certain number of sponsors is seen as permissible. However, no court has yet decided in Germany or in another European country what number of sponsors is the upper limit. Therefore, we refer to an earlier judgment in this context according to which a certain number of sponsors was seen as definitively too large. So now you can see our surveys. We have 2 surveys. Here's the first one. Which number of sponsors has been decided as being small enough? And now you have 1 minute time to choose. Well, we have the answer here, and of course you can see that the majority of the participants have decided that it's 8. And well, you are completely right in this context. 2 is also correct. It is as it is the smaller number, of course, but the court has decided explicitly that 8 is 8 sponsors are still legally allowed, and unfortunately 15 would not be the right answer here in this context. Well, and then we turn over to our next survey, which means which number of sponsors has been decided as being definitely too large. And I would like you to think about it during the next minute. We have the answers here already. So 71% decided that the number 15 would be too large. 29% decided that 59 is too large, and nobody decided on 73. Well, to make it interesting, the last choice was definitely wrong. So it was good that nobody decided on this number, but 59 was the decision of the court that this number of sponsors was definitely too large. And so what do we learn from this? Or what would the CSA recommend in this context? We would recommend that if you want to be on the safe side, you should do not name more than 8 sponsors in this context of the consent, and every number that is higher than 8 could be a risk for your reputation and for the legally background of your consent, of course.
Astrid, if I may, we have a good question here that might be good for this point. I have the question: what is considered a sponsor? If you talk about sponsors, what do you mean?
Well, you have the opportunity normally, if you formulate a consent, that you can add some other companies in which the consent agrees can be agreed as well. And in this context, it is important that the data subject is able to see, okay, how many companies, if I agree how many companies are relevant for me that I agree to in getting information from. So.
All right, thank you. Carry on.
Okay, so then there's another important question that the courts in Germany have decided on as well. That is the number of industry, or the definition of industry or product designations. So we have a survey on this topic as well. I hope, yes, there it occurs. So we have here 5 opportunities to answer on, and as you can see, more than one answer is possible and maybe right. And I see the answer is coming soon. Okay, so here you can see media and journals. The most part is car accessories, pension fund, and 83% baby food. Well, the correct answers are car accessories and baby food. These examples are created by the CSA itself, and the rest is has been decided by the Higher Regional Court in Frankfurt as being not precise enough. So media and journals, capital formation services, and pension fund are definitions that are not precise enough. Well, what we can recommend in this context, try to define the products and services as exact as possible. Now I hand over once again to Alexandra.
Okay, thanks, Astrid. To be honest, I'm really surprised and excited at the same time that theoretically all of you are aware how many sponsors are allowed, and what about the precise definition of product designations. Wow, I assume in the future we will not have any reason to say that consent declaration will violate the CSA criteria. I'm very happy. So hopefully in the future we will have a lot of complaints we can dismiss, is that the right wording in this context? At least, and procedures without notifying officially. So, however, let's come to the customer relationship, which is
before you go into that, Alex, just a quick question, because it came up a bit earlier, but now it's fitting better, I think. So we've talked about consent so far, and you're about to start talking about the customer relationship. So we have a question: does it need to be both existing customer relationship and consent, or is an existing customer relationship sufficient on its own? I know it's at the start of what you're going to talk about, customer relationship, but do we need both consent and customer relationship? So maybe that's a good way to get into this.
Okay, thanks. You don't need to have both. So you need to have either a consent declaration, and if you don't have a consent declaration, you may be allowed sending advertising emails based on a customer relationship if you fulfill additional requirements. So we are now talking about the situation where you don't have a consent declaration, but you have a customer relationship and you think it would be good to send advertising based on this relationship you have with the data subject. So talking about the customer relationship, looking back in the complaints office history, there has always been some issues with that. Funny enough that the issues in detail are varying from year to year. So this year we are focusing on other topics than we did in the past. However, I'd like to introduce you to all the 4 requirements that need to be fulfilled, as all these requirements must be fulfilled to be allowed to send advertising emails. So we think it's good that you know all of these issues. So let's start with these requirements. I think at the first glance it looks and sounds very easy, but let's say the details might be a little tricky. Starting with the customer relationship itself, there are 2 things you should consider. The first thing is it must be an existing customer relationship, meaning that a contract should not be terminated in the meantime, and that it's not sufficient if someone starts the purchase procedure but then cancel it at some point. So then you don't have an existing customer relationship. So the contract must be there. That's the first thing. And the second thing is it must be in return for payment. So if you're offering something for free, then it will not qualify for the customer relationship exceptional case. The second requirement is that you are promoting similar products only, meaning the product must be similar to the purchased product or service before. And as we are talking about an exceptional case, the interpretation of similar product is a narrow interpretation. So it must be for the same purpose, or to some extent then might be also for complementary accessories, but it's not allowed to, let's say, promote makeup, because makeup was purchased before, but then continue with
there you go. I think
airbrush.
I can hear you again. Okay.
Okay, was I just frozen, or shall I repeat, or can I continue? Okay, so if you're promoting similar products, that's fine, but don't put additional stuff to the advertising email. That's the main point here, because if you do so, then you're acting against the requirements and it wouldn't be legally allowed. The next point is that you have to put in an opt-out notice when you're collecting the data, but also when you're using the data. And the tricky thing here is that you have to use a very specific wording, unfortunately. We saw in the past that the opt-out notice or the note on how to revoke consent is a major issue here facing at the complaints office. That's why we talk about this in detail next week. So I don't want to go into details here, but please keep in mind opt-out notice necessary when collecting the data, when using the data, and don't use some wording, use a very specific wording here to be on the safe side. And last but not least, of course, even if you're sent emails based on a customer relationship, you have to observe opt-out requests. So if there is an opt-out before you're sending the email, then you're not allowed to send the email based on the customer relationship here. As we are not seeing any issues here, we are not focusing on the not obtained opt-out, of course, stage. So I know it was a very roughly kind of brush up on the customer relationship, but I think the main point that we are talking about here are the ones we faced. So I hand over to Sebastian.
All right, thank you, Alexandra. Thank you, Astrid. So far, we've had a couple of questions that I put towards the end. So thank you, everybody who participated in our surveys and little polls, and of course, for your questions that we've answered throughout. And we're going to go through the ones that are still left. All right, so first question. So we've talked about the sponsors, but this is more of a, I think, more of a technical thing, of a setup thing. Don't worry, not a technical question. So can you have like one checkbox for all the sponsors? Do you have to have separate consent checkboxes for if you have for a couple of sponsors? So you can, do you have do you need one checkbox, or is it okay? Do you need a couple? I think I'm sorry, Astrid, I think your mic is still muted. Or Alex, you go ahead, then maybe.
So,
oh, okay, now we can hear you. Perfect.
Okay, sorry, I forgot to unmute me. So once again, Well, it's okay if you have just one checkbox and you put one click there. But in the consent declaration has to include all the sponsors. So there has to be at the end of the consent declaration a list of all companies that the data subject will consent on.
All right, thank you. So then we have another question, maybe since this is about consent, this might be more of an interest to Alex. So we have this question. I think that's interesting. Is there any difference? So there's business to business relations, and there's business to clients, so B2C and B2B. Is there any difference regarding consent? Does it need to be set up differently? Does it need different content? Are there any other guidelines?
There's no difference between B2B and B2C as long as you're using personal data. So if you're using an email address such as first name dot last name at something, then the same regulation applies. There might be some difference if you're using role accounts in regard to who needs to give a consent and all that stuff, but the usual case is what we also see in complaints office, that individual email addresses are affected, and in this case there's no difference. So yeah, even if you're contacting a business contact, then you have to have the permission.
All right, thank you. I hope this question is answered. Please feel free to post more questions. We do have one or two. First one, we're talking about consent right now, so let's keep doing that. What if there is a minor involved, since it's all about the GDPR and there's age restrictions? So what do we have to check for minors? Do we have to verify age, and if yes, if yes, how so? Feel free to answer, whoever wants to.
Okay, thank you. So I will answer this question. First of all, the data protection authorities in the European community have not yet given any advice how to deal with this problem. So we do not have a safe regulation in this context. Anyway, if you think that on the other side there's a minor, you should of course figure that out, and then the parents or the guardians have to give the consent in this context. And we hope that sometime there will be a guideline in this context of the data protection authorities, but to that point we have to act in that way as I described it.
All right.
An additional point on this here, that's for instance the reason why at the CSA we don't would sanction any violations of these requirements that laid down in the GDPR, because we know there's no recommendation from the data protection authority, and it's hard to comply with these legal requirement here. So we just make you aware that there might be the necessity to check this, and you're just putting together consents, but we wouldn't check or assess this when it comes to a procedure at CSA.
Okay, thank you. One more question. Yes, we've had this question before, sort of differently though. So we've asked the question whether we need both consent or customer relationship in customer relationship cases. What if we have both? Can we combine them? Is there any way that is okay, or is it even recommended or not recommended to, for example, put in the sign-up process if you're buying a product, say in a web shop, and then get consent there? Is that something that is okay?
From a legal point of view, it's okay to combine both, but please think of the impact the combination could have. So, for instance, if you're having a purchase order and put in to some extent the note and request that you want to also send afterwards your newsletter and you're asking for the consent. And if you're at the same time are not referring to the possibility to send advertising emails based on the customer relationship, then there might be a wrong feeling or a wrong expectation at your client, thinking, okay, if I don't subscribe to the newsletter, then I will not get any advertising email. And afterwards, you're sending the advertising email and people are confused and they start to complain either to us or to their mailbox provider, which will lead to a bad reputation because of spam clicks and all that stuff. So if you want to combine that to cut things short, then please put both options very close to each other so people know at one look, so to say, that you want to send advertising emails at least based on the customer relationship. And yeah, so people don't have the wrong expectation here. So put both options close to each other, then you're fine.
All right. Well, so far that has answered all the questions that we've gotten. So thank you very much for participating. Thank you. And please do join us next week. Sign up if you don't have already. Same time, just 1 week from now. We'll talk in detail about opt-out notices and stuff like the legal notice information imprints, things like that. And one last thing, we kindly ask that you give us some feedback by filling out a short survey, either right after this show or through an email that you'll receive tomorrow, I think. So thank you very much and have a good night.
Bye.